After the Supreme Court granted, vacated, and remanded review of a critical magazine ban case, a lower court has now continued to defy the Supreme Court and has upheld the magazine ban, but at the same time, they struck down a narrow aspect of a state's rifle ban, and this all came in the same decision. So let's talk about what is happening in this critical case. Now, really quick before we jump into this video, I just wanted to mention that looking at some of my analytics, about 60% of all my viewers actually don't subscribe to this channel. They're not subscribed. So if you guys want to support this channel for free, one of the ways to do that is simply subscribing. And then also if you click the notification bell and you turn on all notifications, that ensures that YouTube will actually send you these videos. And then also just double check to make sure YouTube is not unsubscribed to you, because they love to do that without you knowing. As I mentioned in the intro, in this video, I'm going to be discussing and breaking down two critical cases which challenged a state's ban on so-called assault weapons, essentially their rifle ban, and then also their magazine ban, essentially a ban on magazines that hold more than 10 rounds. Now, this magazine ban case was recently granted, vacated, and remanded back down to the district court in a New Jersey court, and this was in light of the Supreme Court's recent 6-3 decision in the Bruin case. Well, the district court, on re-review of this case, decided two consolidated cases, which were the A&J RPC versus Platkin case, and then also the Cheeseman versus Platkin case. And this all deals with the state of New Jersey's restrictions on rifles and magazines. And in this ruling, that district court came to the most perplexing and essentially outrageous anti-Second Amendment analysis that I have seen out of any court. The court found that the state of New Jersey's ban on Colt AR-15s is unconstitutional and must be struck down in the narrow aspect as far as the restriction on just those specific rifles. However, in that decision, they essentially decided to not rule on any other aspects of the state's ban on so-called assault weapons, so they avoided any of the other firearms bans. And then also they found that the state's magazine ban is constitutional, that it does not violate the Second Amendment, and therefore the state can restrict the access to these types of magazines. This egregious decision has now been appealed up to the Third Circuit Court of Appeals for reversal, and this is a critical challenge, and it's necessary to undo this clearly incorrect and outright defined decision that this lower court issued. This is a decision that clearly the lower court was bound by Bruin. It knew that it could not completely skirt Bruin, but it did everything in its power to not faithfully apply that decision. Now, this case, like I mentioned, involves the state of New Jersey's ban on so-called assault weapons and then also their magazine bans. When it comes to the magazine ban back in 2018, the state of New Jersey passed the Assembly Bill 2761, which banned the possession of firearms magazines with the capacity to accept more than 10 rounds. This law in New Jersey required owners to either modify their magazines permanently to essentially reduce the capacity, to destroy them, or to turn them over to law enforcement officers. Now, back in August of 2018, the district court on review of this case denied A&J RPC's motion for a preliminary injunction that would have prevented this law from going into effect. This case then moved forward, and ultimately what happened is the state of New Jersey won this case on a motion for summary judgment. This was then appealed up to the Third Circuit Court of Appeals, and ultimately the Third Circuit ruled in favor of the state of New Jersey. Then there was a request for en banc panel rehearing in the Third Circuit, but at that time, the en banc panel denied rehearing. At that time, then the plaintiffs, A&J RPC, sought Supreme Court review, and this was back in 2022. At that time, the Supreme Court was set to review and decide the Bruin case. They eventually issued that decision. It set the analysis of text, history, and tradition. And then in light of the Bruin decision, A&J RPC, which was on hold, was then granted, vacated, and remanded back down to the lower court for a new decision in light of Bruin. When this case got back in the hands of the district court, there were other lawsuits going on, like the rifle ban out of New Jersey. And what ended up happening is the district court then consolidated multiple cases dealing with the magazine bans and the rifle bans. And then it issued its decision, which again, like I mentioned, was a horrible mixed decision that did not faithfully apply Bruin. In its decision, the judge stated that it's hard to accept the Supreme Court's pronouncements that certain firearms policy choices are off the table when frequently radical individuals possess and use these same firearms for evil purposes. Even so, the court's decision today is dictated by one of the most elementary legal principles within our legal system, which is stare decisis. That is, where the Supreme Court has set forth the law of our nation, as a lower court, I am bound to follow it. For these reasons and those below, the AR-15 provision of the assault firearms law is unconstitutional. It then stated that the LCM amendment is constitutional. So in this ruling, the district court said that it does not believe that the Supreme Court got the Bruen analysis right, but it says that it's going to faithfully have to follow that Bruen decision, but then it goes on to simply not follow Bruen at all. Now, when it comes to the rifle bans, he found that given the variety of firearms regulated in the assault firearms law and the nuances that each individual firearms presents, the court's analysis of the AFL is limited to the firearms with which the court has been provided the most information, the AR-15. For the reasons enumerated below, the AR-15 provision is unconstitutional. Accordingly, the breadth of this decision is limited by the fact that the remainder of those assault firearms laws stand since it has not been challenged in this case. So that's the part where the court is limiting this ruling only to the AR-15, and it says that the ban on Colt AR-15s is unconstitutional. Now, the court here also says that all of the briefing was specific just to these types of ARs, to just those rifles, but that's not true. There was a ton of evidence and a lot of arguments that were made in this lawsuit as to other firearms that are banned under this law, but oftentimes when it comes to these types of discussions and these arguments in the court, the example is always put forward as the AR-15 because that is the most common firearm. That's the one of the ones that is mainly targeted in these types of bans. So that's what the plaintiffs here are presenting as the example of the types of firearms that are being banned. But that doesn't mean that the decision here should be limited just to those, because the law bans a ton of other semi-automatic centerfire rifles. But the court here tried to skirt actually striking down all of the firearms bans and said, I'm only going to rule on just AR-15s. Then when it came to magazines, the judge again did everything possible to twist the Bruen decision to essentially uphold this ban. He stated in his ruling that the LCM amendment presents different issues, and the nuanced analysis is implicated. The state defendants argued that the unprecedented rapidity and damage by these types of items is supported and supports a more nuanced reading of the historical analogs under Bruen. So in the decision, the judge strikes down only the AR-15 part of the assault weapon ban, and then he avoided ruling on any of the other firearms bans, and then he goes on to also uphold the magazine ban. Now, this is a horrible decision, and it's mixing and matching and doing a hodgepodge of Bruen analysis and then avoiding Bruen altogether when it needs to. But that decision, this decision here, is now being appealed up to the Third Circuit Court of Appeals. In the appeal, the plaintiffs argued that the court below started off on the right foot, holding that the New Jersey ban on AR-15s, America's most common civilian rifle, is unconstitutional. But the court then arbitrarily cut plaintiffs' challenge to all of the rifles, pistols, and shotguns that New Jersey outlaws as assault firearms down to just the most popular. That was inexplicable. To be sure, the plaintiffs sometimes use America's most popular civilian rifle as an exemplar of the kinds of firearms that New Jersey's prohibition encompasses, but that in no way negates the pages and pages of summary judgment briefing, expert declarations, and pleadings that the plaintiffs supplied addressing the full suite of firearms that are banned here within the state of New Jersey. Even more troubling, the court relied on the fact that defendants focused on the AR-15, thus improperly allowing the non-movement to shape the movement's summary judgment motion. So they're saying just because the state of New Jersey only addressed AR-15s does not mean then you just limit your decision to the AR-15s. If they didn't defend any of the other firearms bans, well then that should go in the plaintiff's favor instead of you limiting the scope of your decision. They go on to argue that meanwhile, as to magazines, the district court correctly held that the banned magazines are arms covered by the Second Amendment's plain text. It recognized too that they are in common use for lawful purposes. But things went south from there. In attempting to apply a nuanced version of analytical reasoning, the court suddenly, and without explanation, held that the state's ban on possessing these arms was merely a restriction on how people may use those items. So the plaintiffs in this lawsuit have now taken this case and that decision back to the Third Circuit, and they're trying to get the Third Circuit to reverse that lower court decision. So this is a very critical final merits appeal that is now back in front of the Third Circuit. The Third Circuit really has had a mixed track record in the past. I would kind of put them as anti-gun, not as bad as the Ninth Circuit, but still not that great. But as of recent, the en banc panel in cases like Range versus Garland have been a little bit more favorable. They've been ruling pro 2A. So maybe that kind of signals a shift in the Third Circuit at the larger level, the en banc panel level, especially in a post-Bruen world. So maybe the tides are shifting a little bit and maybe we can get more pro 2A wins out of the Third Circuit. And so as we get more information, as this appeal develops, I will let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. But as always, thank you guys for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.